Hello, I am Attorney Masah SamForay of the Foray Firm with offices in Chicago and in Houston, and I am back again to talk to you about all things immigration. So today's question is, I'm considering overstaying my visa because of a denial. What should I do? What do you recommend? So it's very common to feel this way, especially if you've had a denial of your adjustment of status and you're already on the shores of the United States. Then certainly if you receive a denial, not only is it devastating, but it could put you in a position where you have to be separated from friends or from loved ones or for the life that you started to build or hoped to build in the United States. Your I-94, meaning your visa, had a deadline. Your visa had a deadline and it was very clearly marked. And even though obviously ICE and USCIS do have record of this deadline, it's not as if there are going to be ICE agents at your door the following day as soon as your visa expires. It could take months. It could even take years for them to catch up to you and to send you a notice to appear at an immigration proceeding. And so I get it. It could be tempting to want to overstay. So what I want you to do is to consider the consequences. So for instance, depending on how long you overstay, that could directly correlate with the number of years that you will be barred for re-entry once you're caught. So if you overstay by 180 to 364 days, so less than a year, that could equal a 3-year bar to re-entry into the United States. If you overstay by 365 days or more, that could equate to a 10-year bar, depending on the circumstances, for re-entry into the United States. Because if you overstay, you're going to have additional challenges. It could really affect your future immigration status and whether or not you will ever be able to be eligible to come back legally or lawfully into the United States. So you really want to consider the consequences. There are situations where you could get a waiver. For instance, if you could show extreme hardship, not to you, but extreme hardship to your spouse who is a U.S. citizen or a green card holder, or extreme hardship to your child who you might have had while you were living in the United States because you are the primary caretaker, then you might be eligible for a waiver. So what you're gonna want to do if you have received a denial for your adjustment of status is make sure that you consult with an immigration attorney who knows how to assess your situation properly to determine A, whether or not you're even eligible for a waiver, and B, what the likelihood is that the waiver will be granted. Otherwise, the best advice that we can give you, as hard as it will be to do, is go home. Go home and find a legal and lawful way to come back to the United States so that you can enjoy everything that the U.S. has to offer and not have to live your life looking over your shoulder. I hope that this has been helpful, and we look forward to seeing you next time.